Order. We will now hear oral evidence from the Religious Society of Friends and the General Assembly of Unitarian and Free Christian Churches. For the record, could you please introduce yourselves to the committee?
I'm Michael Bartlet and I'm the Parliamentary Liaison Secretary for the Quakers in Britain.
I'm Derek McAuley. I'm the Chief Officer of the General Assembly of Unitarian and Free Christian Churches.
Welcome. Before calling the first member to ask a question, I should once again like to remind all members that questions should be limited to matters within the scope of the bill and that we must stick strictly to the timing and the programme motion the committee has agreed. I hope I don't have to interrupt mid-sentence, but will do so if need be. I call first Kate Green.
Mr. Hood, can you say, if this legislation passes, whether it's the intention of your organisation to offer same-sex marriages in future, and if so, why it's important for you to be able to do that?
On behalf of Quakers, yes, we would definitely want to offer same-sex marriages. For us, it's both a question of liberty and equality. We see the legislation as removing barriers to same-sex couples being able to marry in just the same way as heterosexual couples currently can. And since our yearly meeting in 2009, we've been seeking for exactly this kind of legislation. So we're delighted that the government is making it possible, and we're also delighted that it appears to be in such a way that it's not going to create additional administrative burdens as civil partnerships in religious premises have.
Yeah. The Unitarian General Assembly is supportive of the legislation. Unitarians have been undertaking same-sex blessings for probably 30 years. We were probably one of the very first churches to do that. Our General Assembly throughout the last, again, 20 years has been supporting the increasing inclusion of LGBT people within society and within religious bodies. We're very supportive. The very first religious premises that was registered for civil partnerships was a Unitarian chapel, and in fact the very first civil partnership in a religious premises was also in a Unitarian church. So we're very supportive of the legislation.
And can I ask you, if you have celebrants who are not willing to conduct these marriages, how would you handle that?
In our case, all of our congregations are autonomous and independent, and all of our ministers and authorised people who may be laypersons as well, it will be an individual choice. The fact that the General Assembly is supportive doesn't mean that every Unitarian chapel or every Unitarian minister or layperson will conduct the ceremonies. It's down to individual choice. We promote that and support that view for other churches, and we take that view for ourselves.
From the point of view of Quakers, the problem wouldn't arise. In Quaker weddings, it's the couple who are getting married who marry each other, and those in the meeting are but witnesses to that, and one of the witnesses is the registering officer who is appointed by the local meeting. So the problem wouldn't arise for us.
And are you confident that the protections in the legislation will work in terms of ensuring that you are both able to offer these celebrations without challenge, and equally, in the case of the Unitarians, to for individuals to refuse to conduct them if they wish to?
From our perspective, the definition of the authorising body, as far as we're concerned, allows us to say that the individual churches, chapels, will authorise and make the decision, first of all, whether or not to register the building for same-sex marriage, and then secondly, whether or not to appoint an authorised person, be that person the minister or be that person a lay person. So I think that those safeguards apply for ourselves as for others. I think the legislation is clear there. We do welcome the fact that the processes are similar to marriage, but an additional step. So there won't be the bureaucratic burden that there is with civil partnerships and religious premises, and I hope there won't be the cost, because one of the big impediments against civil partnerships in religious premises has been the fact that local authorities are sometimes charging £1,000, £2,000, £3,000, which is way above what is reasonable in many circumstances.
And from the point of view of Quakers, we're very comfortable with the legislation. We also feel it's important that no denomination is compelled to do something which they wouldn't do. And I think from our point of view, we feel that the legislation strikes a fair balance between different denominations in enabling those like ourselves who would like to be able to, while not compelling others who don't currently feel that's what they want to do.
Thank you.
Tim Lawton?
Thank you, Chairman. Could I, Mr. Bartlett, just explore a bit about the Quaker position, because I'm not as familiar as perhaps I should be, particularly as I have some particularly persistent Quakers who write to me from my constituents on a regular basis about all matter of things. You said that you don't marry people. The members of the Quaker Church are only witnesses, and that was set down by George Fox in 1669. What he exactly said, I gather, was friends cannot consent that they should join them together, for we marry none. It is the Lord's work, and we are but witnesses.
Yeah.
Can you explain to me the process, therefore, that happened so that in 2009 you became in favour of being witnesses at same-sex marriages?
Yes. Firstly, on the point of being witnesses to a marriage, I think properly that's also the theological understanding more broadly in the Christian Church since the Council of Trent, that it is actually the couple themselves who make the commitment in the presence of God. From the point of view of Quakers, we've since at least the 1960s been concerned at the problems that gay people have suffered in society. And for a long time, many Quakers, since a book written on Towards a Quaker View of Sex in the 1960s, we've been concerned that gay members of our community should be able to play a full part, as full a part as heterosexual members. We make decisions at our annual body, our yearly meeting, to which all members of the Society of Friends are admitted and can attend. And it was a remarkable experience in 2009 in York. We weren't expecting to go as far at that stage as asking specifically to be able to marry same-sex partners, but there was an overwhelming consensus. And I think I was there myself, and I think what really influenced the yearly meeting in session was the stories of gay people and the ways that gay people would like to be able to celebrate the fullness of their loving, committed and faithful relationships in exactly the same way as our heterosexual members can.
Can I just follow that up? I fully appreciate that. What I'm trying to get my head round is what really changed, because I'm particularly keen to investigate what changed between 2004 when we had civil partnerships that came in and now that we need to go on to full-blown same-sex marriage. Was there unanimity in 2009? Is it possible that at your yearly meeting in the future you may reverse that decision? And are there a number of your celebrants who disagree with that situation, who may refuse to participate in these ceremonies in their friends' meeting houses?
I think talking from the point of view of Quakers in England and Wales and Britain yearly meeting, there was an overwhelming consensus, and those who felt uncomfortable about it may have had personal reservations, but recognised that it was the overwhelming will and sense of discernment of God within society, that's what we were asking for. I would think it would be as unlikely as our feeling that women would not play as full part in the society as men in the future, that we would want to go back on that. It is really a sense of our settled religious experience that we would like to be able to marry our same-sex partners in our meeting and in a worshipful meeting.
So you think it will happen in every premises of the Quakers around the country if this becomes law?
We're a society with quite an ageing profile, and I'm not sure that every...
so we all...
even in terms of heterosexual marriages, they don't take place in every meeting, but I wouldn't feel there would be meetings that would in any sense be opposed. And as I was explaining earlier, it isn't that we have a celebrant, it is that we have a registering officer appointed by the area meeting who is the witness and reports the marriage legally to the state.
Okay, thank you.
Stephen Williams.
Thank you, Stuart. I have 3 Quaker meeting houses in Bristol West and a Unitarian church as well, so I very much look forward to same-sex weddings taking place in all 4 of those locations. later this year. Do either of you favour the extension of the right to marry loving couples to other organisations such as humanists?
As regards Quakers, it isn't something that we've considered in our decision-making process. Personal view, I would feel comfortable with it, but it isn't something we have a settled view within the Quakers, within the Society of Friends.
Similarly, the Unitarian General Assembly hasn't discussed, although if one goes back in history, the actual extension and creation of civil marriage, Unitarians were very supportive of civil marriage because that enabled atheists to get married rather than having to go to what was then only the Church of England apart from the Jews and the Quakers. So the logic of that would point to being supportive, as in Scotland where humanists can carry out marriages, supporting that, and other groups.
Thank you. Thanks. One more. From the information we've got, it seems there are about 23,000 Quakers in, across Great Britain, it says here. I just wonder how many Unitarians there were and whether you've assessed in any way how many weddings are likely to take place in the foreseeable future in your meeting houses and churches?
There are about 5,000 plus members, plus attenders and friends. So our community is very small. We've always been small in numbers. Even back in 1851, the Great Census, there were 26 million Church of Anglicans and 46,000 Unitarians. But that doesn't mean that the freedoms that we were aspiring to then, there was we wished to have a Unitarian Marriage Act in order that Unitarians could get married in the same way that Quakers could, because until 1837 Unitarians had to be married in the Church of England, although that was in many ways offensive to our religious views. So that's it. We are open in terms of marriage, in terms of who we will marry. You don't have to be a member of the Unitarian denomination to be married in the Unitarian Church. We were very receptive in the 1960s to divorced couples, and still are, who couldn't get married anywhere else. We were also very receptive to mixed faith couples who found themselves in a situation where neither of their religious group that they belonged to would marry them, and people have come to Unitarian chapels and churches seeking a marriage, seeking a religious element, because they believed that actually just having a civil marriage was not sufficient. We're, in terms of the way we perform marriages, we clearly comply with the legal requirements, but the minister or authorised person will discuss with the individuals the nature of that marriage and the flavours that we can integrate within that. So we're very flexible, and we would anticipate with same-sex marriages that, as we have done with civil partnerships on religious premises, in the very few cases that have taken place, that we will adopt a similar approach.
Ben Bradshaw.
I think you may have just answered my question, Mr. McAuley, but I wanted to ask whether it's currently the case for both of you, and will be the case with same-sex marriage, that you don't have to be a Quaker or a Unitarian to have the ceremony in one of your premises.
That's correct. We would we take people at face value, and if they come in good faith to us seeking a religious ceremony, we will normally go with that.
From the point of view of Quakers, Quaker marriage procedure isn't an alternative form of marriage for the general public, and whilst many people who marry in Quaker meetings may not formally be members, it is something for people who are in sympathy with Quaker views and see themselves as adherents, and part of the process in preparing for marriage takes place in the context of our area meetings. So it's not something for the general public, but for those who do share Quaker values.
Some of the other religious organisations that we've heard from who are opposed to this legislation base their opposition on their approach to Scripture and doctrine. I just wondered how your approach to Scripture and doctrine had led you to a different conclusion.
I think from the point of view of Quakers, we see the Gospels and the Bible as very important, but we don't see it in any sense as a literal truth. It has to be read with the spirit of love, and it has to be read in the context of time. And I think it's really over the last 3 centuries, just as there's been a move in the general public to accept much greater equality of women, there's been a move to understand that wrongs in the 17th century, such as slavery, are no longer seen as wrongs. We'd see a similar process as happening in our understanding of gay people and human sexuality. And we don't in any sense see it as against the spirit of the Gospels, but we don't take the literal views that some Christian denominations might.
Yeah, in terms of scripture, the Unitarian approach would be that although we came out of and are based within the Christian tradition, and if you go to many Unitarian services, they look like a traditional Christian service, hymn, sermon, prayers, reflection. We draw on the traditions not just of Christianity but of other traditions. We will draw on humanist traditions. We look at the creative work of artists, musicians. We look at science. So we will draw on lots of spiritual insights, not just the Hebrew scriptures and the New Testament. Although historically for Unitarians the figure of Jesus as a man was obviously significant, but we will, in this century, we will draw on other historic figures as well.
David Burrows. Okay. Tim Lawton.
Mr. Bartlet, can I come back to you a couple of points? How many members have the Quakers got at the moment?
If you look at both members and those who are in sympathy and regularly attend, it's about 23,000. I can give you the exact figures here for...
That'll do, don't worry. 23,000-ish is fine. What I'm interested in is your name has been prayed in aid, along with the Unitarians and the Liberal Jews, an awful lot by the government and the proponents of this bill. And by my rough calculation, your combined congregations amount to 38,000 people. What is your relationship and what is the Quaker view, because in my experience of dealing with Quakers, it's slightly different from other religions, of government and the role of government and how beholden you are to government or not?
Thank you, that's a very good question. I think since the time of the Commonwealth, Quakers have always had a relationship with government which hasn't been entirely easy, in that we've always had a very high view of conscience and the importance of following your conscience. That, however, also goes alongside a deep respect for government and a deep respect for the rule of law. I don't think Quakers have ever sought to justify the legislative change we have sought on the basis of numbers. So, for instance, Quaker marriages were first implicitly recognised in Lord Hardwicke's Marriage Act in 1753 and then explicitly recognised in the Marriage Act of 1836. And I think if you were looking in the 19th century, I can again give you exact figures if you want, but I would be surprised if there were more than around 100 Quaker marriages a year. It's not something that we ask for on account of numbers. It comes from a sense of the indivisibility of religious liberty and the sense that if the established church and the Roman Catholic Church should be able to follow its religious leadings, so should smaller religious groups such as Quakers and our Unitarian brothers and sisters.
Sure, I don't dispute that, but what I'm trying to get at is why do you need government to legislate that marriage can now be a different thing between same-sex couples? What is to stop your particular faith, which is a bit different from the other faiths we've had here, performing the ceremony, and I want to follow on by asking about that, and saying that these two same-sex persons are now Quaker married, regardless of what the government would view it, because you don't believe that the government should trump your view of what marriage is because you're only witnesses to it, because it's something that God gives those two people. So why do they need to be married in the eyes of the government?
And that wasn't exactly my words using trumps, but to go back to the 17th century, when Quaker marriage developed at a time of persecution, what we felt there was both the need to provide pastoral insight, pastoral oversight, and a sense of recognising the important experience that was taking place in a marriage between a couple who are committing to each other in the spirit of God, the importance of both holding together that inward religious sense in a spiritual ceremony with having careful, considered reports of those marriages which would be recognised by the state. And right from the early days of Quakers, the spiritual and the legal have been indivisible in marriage. And indeed, that's recognised in the 1949 Marriage Act in our ability to appoint our own registering officers. It is both a relationship which is inward and spiritual and has an outward and legal concomitant. What matters for us today is that we would like same-sex couples to be open to the same process so that we don't discriminate, so that barriers are removed so that they can access marriage just as currently heterosexual couples can access marriage.
I don't want to hold the question because this is a fascinating debate we could have all day. I don't think you've answered my point as to why you still need marriage to change in the law for you to be able to marry under Quaker ceremony your same-sex couples. The other point I just quickly want to ask you, though, is you say it's down to the two people who decide to get married, and you are just witnesses to it. How can they tailor-make their ceremony, and could they, because I haven't been to Quaker wedding, I don't know how it works, could they effectively say that we want our Quaker wedding ceremony not to have any mention of God in it?
A Quaker wedding ceremony takes place in silence. The
That
gathered
answers my
meeting.
question then.
No, sorry, I was going to say, to start with, it takes place in a gathered silence, but there is also a very clear prescribed form of words which has to be used at the time that the couple make their commitment to each other. And they say, friend, they stand in the quiet of the meeting and say, friend, I take this, my friend, to be my husband or wife, promising through divine assistance, or if they like to say that, with God's help, to be unto him or her a loving and faithful husband-wife, so long as we both on earth shall live, and the registered signed. That's a form of words that needs to be used. But just to come back to your previous question, if I didn't answer it fully, the importance for Quakers is that the spiritual and the legal and practical are all brought together in that one form of commitment.
Mr. Clark,
thank you very much for that full answer. But I'm very interested in the aspects of this particular bill and the protection that it gives the Church of England, in that the Church of England has been essentially sort of ring-fenced. I just want to know what you thought about that, the special protection given to the established church.
I think, as a denomination, we feel it's important that the state provides equally for denominations and recognises their own religious insights. On a personal view, I wonder whether quite so many locks are necessary, sure. But that's not the view of my denomination. We are comfortable with the legislation for Quakers and recognise that it's important that other denominations can also be comfortable with it.
So how, forgive me, how watertight do you think this quadruple lock is?
I wouldn't want to add anything to the evidence of David Pannock and Helena Kennedy, who I think covered that brilliantly in their evidence.
Thank you.
Jim Shannon?
Good, and gentlemen, questions, same question to both of your organisations. In relation to Unitarians, I think you referred to about 10,000 Unitarians was the number I believe you referred to as you have at this moment in time. Is that correct?
I said about 5,000 members and regular attenders, friends, supporters. So yes.
Yeah, and for the Quakers, it was about 23,000 thereabouts. I'm just wondering, have you any indication of? Obviously, you're not taking away from your churches, but your small churches, small minority churches, but your opinion obviously is also important to this committee. I just want to put it into perspective. In relation to, say, 10, 20 years ago, would you say your numbers have fallen greatly? That's the first question. Second question is, as an organisation, I'm sure while you have been able to have your blessing ceremonies and for same-sex relationships over the last number of years, if you inadvertently posed legislation that made it difficult for the other large churches with obviously millions of followers across the whole of the United Kingdom, would you feel that what you were doing here today would be wrong for that reason? And I also just want to get an idea. I think in the Quakers you mentioned about 100 marriages over the last period of time. I'd be interested to hear how many marriages have been carried out in Unitarian churches over the last number of years as well, and do you see those decreasing?
Right, I think the first question was, have we fallen aside? Yes, we have declined for decades, following the trend of all religious main groups within Britain, particularly the historic denominations. The second question was, would we...
legislatively, if there was legislative change coming through this committee, this bill committee, and ultimately to be passed by the House, do you, and by that you inadvertently or complicitly by witnessing to this committee today, of course, had a change that impacted upon the larger churches, those who have millions of followers. How do you feel about that there?
We feel ultimately we have our own perspective. We put forward our views. We believe that Parliament should allow us to conduct same-sex marriages. Parliament should address the concerns of other denominations in the same way, taking the principle of religious freedom. And we recognise, in answer to the previous question, the particular situation of the Church of England and the Church in Wales, given their legal responsibilities. So we feel that the legislation shows a way forward that can address our needs, and the needs of our members, and the needs of those churches who do not wish to perform same-sex marriages.
My question to you, Mr. McAuley, was this. I was asking how you would feel if it impacted upon all those other larger churches and the millions of followers that they have, and they felt victimised, discriminated, or annoyed, or angered, or displeased, whatever terminology. How would you feel about that? I'm just asking. I haven't answered that question.
Unitarians over the centuries have been discriminated against and persecuted. We're only celebrating in this year the 200th anniversary of when legislation was passed through Parliament to allow Unitarians to actually hold their beliefs. So we are conscious of how other people will feel. And I would hope that Parliament will take account of that in the legislation, and that no one will be forced to do what they do not want to do, either as institutions or as individuals.
Last question was in relation to the marriages. You hadn't indicated many marriages.
We don't know, because our congregations are autonomous, and we are an assembly of autonomous congregations. We don't collect that information centrally. I am aware that there are some churches that are very popular and will do 10, 15, 20 marriages. There are some churches that will do very few, because they're maybe in rural locations or they're in city centre. So we don't actually know in terms of marriages.
David Burrows.
Sorry, Mr. Hood, I hadn't got a reply from the
Very briefly.
The same questions today.
Thank you. Briefly, in response from Quakers, looking at the most recent years, we have records for 2010 and 2011. Whilst the number of adult members has fallen slightly from 14,260 to 14,031, actually the number of members and attenders has increased slightly from 22,875. Sorry, can I give you those figures in a written note afterwards? Because I'm not sure they're accurate. But I think we would feel that in other countries which have accepted same-sex marriage, such as South Africa and Spain, the sky hasn't fallen in, even for those denominations like Roman Catholics, who are predominantly wholesale at the moment opposed. What we value about the government legislation is it seems to provide a possibility for those denominations like the Church in Wales that might in the future want to opt in to be able to do so at a time when they would feel ready and comfortable to do that.
David Burrows.
Just three brief questions. So the Unitarian Church will be opting in to perform same-sex marriages. My understanding, is that right?
Each individual congregation will have the opportunity to make its own decision to opt in.
Okay. And in terms of the position, whether it's the Unitarian Church or generally, the position for a minister in a church that collectively has opted in to perform same-sex marriages, but that individual minister doesn't want to conduct them. Do you share the concerns? We'll be examining this later with the Equality and Human Rights Commission. Their view that, from their legal opinion, that the bill in its present form could amount to the state acting unlawfully by interfering with the freedom of religious organisations to enforce their religious doctrines within their particular organisation, and the bill does not clearly provide for the freedom of religious organisations to ensure its employees or officials act in accordance with its ethos under Article 4 of the European Union Framework Directive. Do you share those concerns, and particularly given the rich heritage of conscientious objection that the Quakers have?
We certainly consider that the fact that we're having processes based on the current marriage legislation where the building is registered, and then you appoint an authorised person, which is the rules that we currently apply to marriage, are being supplemented by a second step in both cases. So the building has to be registered for same-sex marriage. So the fact that you're registered for marriage is not sufficient, and there are some Unitarian chapels, at least one I'm aware of, isn't registered for marriage, let alone will be seeking same-sex marriage. They don't want the hassle of the administration. They will perform same-sex and opposite-sex blessings. Then the second stage, in relation to the individual, the celebrant, the authorised person, that again gives a safeguard there. So if the safeguards are apply in marriage to protect individuals, those safeguards, will be reinforced for someone who did not want, for their own personal reasons, to be the authorised person for that particular situation. And you can.
And in terms of this issue, and just more generally, in terms of the whole area of conscientious objections, whether you see it or have any concerns to the Quakers as well in relation beyond the church ceremony, beyond into people's workplaces or schools or the like, do you just want to get your views about that as well?
I don't think, from the point of view of Quakers, I don't think on this issue the problem of conscientious objection arises. Again, I was fully satisfied by the evidence that I heard from David Pannock and Helena Kennedy, and the government has clearly sought legal advice over the compatibility with convention rights, and to me the bill would seem to strike a good balance between Article 8, rights to family life, Article 9, rights to freedom of religion, conscience and belief, and Article 12, right to marry, and Article 14, and prohibition of discrimination. So it does seem to us to be a balanced bill that provides both for those religions who want to celebrate same-sex marriage to be able to do so, whilst being a permissive bill that doesn't compel anyone, individual or denomination, to do so who doesn't wish to do so.
Have you had a chance to look at the legal advice of Robin Allen, QC, who expresses reservations? And just finally, I suppose in terms of impact assessments, have you considered any impact, certainly positive impact? We've heard, the open doors there will be for same-sex marriage ceremonies on your congregations in a positive light. Have you given any?
We often find that people who attend Unitarian services, particularly weddings, often find, this is something different from the mainstream. This is what I'm looking for, and come back and become regular attenders and members. But we're not doing it in order to grow. We're doing it because we believe it's right and it needs to be done, and we need to redress a genuine grievance.
Quaker worship is open to all, and we would welcome you or any other member of the panel who at any time would like to join us in Quaker worship.
I've been.
Jonathan Reynolds.
Thank you, Jake. You've both given some extremely illuminating evidence covering why your organisations, your congregations both support same-sex marriage. You'll be aware that one of the objections or concerns from those churches who are against same-sex marriage has been about how teachers with strong religious views will deal with the subject of marriage in the classroom once this legislation is passed. Can I ask you how you believe the subject of marriage should be dealt with in the classroom, given I'm sure your own concern for your own religious views being treated with the same sort of respect you would hope for any others.
The unit, again, this would be a personal view. I think we have to trust the teachers. Teachers are professionals. Teachers who teach in this area of personal relationships will be professionals. There's adequate guidance. We certainly have views on how religious education is taught, and it needs to be religious education rather than religious instruction in schools. Even in faith schools, they should be inclusive. But I'm sure we can trust the teachers. That would be my view.
From the point of view of Quakers, I think we would hope that the kind of pastoral advice that would be given regarding marriage would be that whether of a same-sex or a heterosexual couple, that there is a commitment to a loving, long-term, lifelong relationship of fidelity, and I think that would be the same regardless of sexuality. What I would hope in terms of teaching more broadly across the curriculum is that there is room for teachers both to explain the law as they see it, but also in a reasonable, detached and open manner to be able to explain that a diversity of views is possible and to put their personal view forward in a way provided it wasn't in any way proselytising.
Minister Helen Grant.
Could I just clarify if you're both satisfied with the opt-in procedures set out in the bill?
Thank you very much for that. From a Quaker point of view, yes, we're comfortable with that, and we also appreciate the particular reference to the recording clerk as the right authority for Quakers, so thank you.
And from a Unitarian point of view, we are happy with the bill and the opt-in clauses around buildings and individuals, and the sensitivity to our particular needs.
Just briefly, if I might, not on behalf of Quakers, but I can recognise from some of our nonconformist friends in Welsh nonconformists, for instance, that there may be a complexity for their opt-in, and that might be something that would be helpful to pursue with them. But for ourselves, we're certainly happy.
Chris Bright.
It seems the hierarchical churches have had a more difficult process to come to changing their mind on these kind of issues, and opinion polls seem to suggest that in the Church of England and elsewhere, the members of the pews support change. But the hierarchy doesn't. But can I ask, do you ever hold your meetings in other people's religious buildings?
There are some places where we do have that kind of a sharing arrangement, yes.
Chaplaincies and the like?
I think there are certainly cases where we share with Unitarian meeting houses.
But you don't hold any events in Anglican churches?
We certainly take part in ecumenical services at a local and national level. I'm not aware of any Quaker marriages taking place in Anglican churches, though.
The sort of reason I'm asking is because one of the ironies may be that we pass all this legislation, and the one place where you won't be able to have a same-sex marriage is in the Palace of Westminster. And I just wonder whether Quakers or Unitarians would like to have the same opportunity afforded to the Roman Catholic Church of holding services in St Mary's, Undercroft.
Yeah. It's not something we've thought of. But
can I suggest you think of it now?
But we have on occasion, with the former chaplain, had Quaker meetings in the House of Commons and have very much valued the opportunity for doing so in the chaplain's room.
Yeah, I'm sure Unitarians would welcome the opportunity to hold a service in the Palace of Westminster.
Great, thanks.
Stephen Doughty.
I've had the pleasure of attending a number of Quaker services over the years, and truly been some of the most moving and beautiful services I've attended. Sadly, mainly funerals, but remarkable. I haven't had the pleasure of going to Unitarian, but I hope to at some point. You raised an issue, Mr. Bartlett, about complexity for nonconformist churches in Wales. Could you just explain that a little bit more? I didn't quite understand.
I don't in any sense speak on behalf of nonconformists, but I'm just aware of the difficulty for some denominations who don't have the clarity of decision-making process that either Quakers or Unitarians have, or indeed the larger churches have, and that that's something which it may well be worth talking to the free churches to make sure that the variety of their religious decision-making is that there's room for them to opt in the bill.
Okay, that's very helpful.
Tim Lawton.
Following on from my question about your relationship with the government, Mr. Bartlett, what would the Quakers' view be if the government reintroduced conscription?
Reintroduce prescription?
Conscription, not
conscription. I think.
Order. I don't think that's relevant to
well,
the bill.
Can I explain why it is?
No, I'm sorry, you can't explain why. It's not relevant to the bill. Ben Bradshaw?
If a lesbian or gay couple came, I think this is a question for Mr. McAuley, really, because the Quakers are very different. If a lesbian and gay couple came to you, Mr. McAuley, and wanted to bring their priest, who wanted to marry them, but whose own church forbade that, how would you handle that situation?
In each individual circumstance, the minister or the layperson, it would be up to the authorised person to discuss with the couple how that could be incorporated. Clearly, the authorised person has to carry out a particular function in law.
Could that priest be the authorised person?
No, because the congregation governing body will appoint an authorised person, so it wouldn't be someone in another denomination. But I could see a situation where that Church of England vicar could be invited to participate in the service, contribute to it, but it would have to be according to the Unitarian views. Excellent. And how a Unitarian marriage is performed.
Thank you.
But we are quite broad in how we do things.
Well, this may have to be the last question. It's now 12:13. Mr. Stephen Williams.
Thank you, Mr. Hood. It was actually based on a question from Mr. Lighton that was in order earlier, and that's about the size of congregations and whether Parliament should take note of minority viewpoints, no matter how small. Would you agree with me that actually Quakers and Unitarians have been at the forefront of holding minority opinions in their time, including setting up the world's first anti-slavery organisation in Clifton in Bristol in my constituency in 1783, which of course is not at all popular view at the time, and sometimes views that are held by a small number of people to start with can change the world, and that's partly what your faith is about.
Yes, some Unitarians have been at the forefront of social reform. We may be small in number, we have had an impact more than our size, and often we speak for a much wider constituency rather than simply ourselves. We were very, over the years, worked with the Quakers around slavery, William Smith MP, and we worked with William Wilberforce on slavery, not just with the Quakers. So, yeah.
No, thank you for that. And I think we see our commitment to same-sex marriage as one aspect of equality, but equality for Quakers is something much deeper, both on a religious and secular basis, and we are concerned that everyone in this country has access to the full goods of society as much as is possible.
Order. I'm afraid that brings us to the end of the time allocated for the committee to ask questions of these witnesses. Can I thank you on behalf of the committee? We will now hear oral evidence from the Methodist Church and the United Reformed Church. For the record, could you introduce yourselves to the committee?
I'm the Reverend Gareth Powell, the Assistant Secretary of the Methodist Conference.
I'm Dr. Augur Pearce, Secretary to the Law and Polity Committee of the United Reformed Church. That's polity, not policy. And we advise on our denomination's internal rules and on the effect of the law of the land.
Chris Bright.
Could you just clarify, both of you, England or England and Wales?
From the Methodist point of view, England, Wales, Scotland, Malta and Gibraltar.
The United Reformed
What's wrong with
Church...
Northern Ireland?
That's a separate conference.
The United Reformed Church has local churches in England, Wales, Scotland, Jersey, Guernsey and the Isle of Man, but also not Northern Ireland.
That sounded a bit like one-upmanship. You're listing more places. Anyway, could you just want to lay out the formal position of your two churches?
The position of the Methodist Church is that our doctrinal standards and our liturgical texts hold to the traditional Christian viewpoint that marriage is between a man and a woman. In addition to that, over quite a long period of time, the Methodist Church has sought to engage in broader conversations about the involvement in the life of the Church of people who are in same-sex relationships, and has committed itself not only to continue that work, but to value faithful relationships in the life of the Church. There will, of course, be a wide range of views in respect of that particular position. Our position, therefore, in terms of the bill, is that we are at the moment bound by the view of the Church in respect of marriage, but have been content with the provisions that have been made in the bill for protection of those religious bodies that are, at this juncture, unable to support the main thrust of the bill.
Can I sort of reply to that and then come to you in a moment further in the URC? So that sounds quite fudgy, if you don't mind me saying, but maybe that's deliberate. I see from the smile on your face that that's deliberate. So you kind of want to like gay people, but you don't want to marry them.
Well, I don't think it's quite as sharp a distinction as that, even though it might feel fudgy for quite a lot of people, which might be why it works, I suppose. I think the point,
like alcohol.
Well, couldn't possibly comment about alcohol, but I think the point is that the Methodist Church recognises that that the question of same-sex marriage has been raised as a result of a piece of government legislation and not as a result of the Church itself raising the question as to the interpretation of marriage. That's rather unlike the question about the support and provision for same-sex relationships in the life of the Church prior to this piece of legislation, because that conversation arose long before there was a legislative programme in place.
But do you think homosexuality is a moral disorder?
No, that's not the view of the Methodist Church.
Right. And would you bless same-sex unions?
The current position of the Methodist Conference is that it doesn't permit for the blessing of same-sex unions on Methodist premises.
But would elsewhere?
Well, yes, and there would be some Methodist ministers who would be very content to bless same-sex unions, but they are at the moment prohibited from doing that on Methodist Church premises.
Right. Sorry, the URC, I guess the same questions really.
The URC came into existence in 1972 when two religious traditions united, and both of those traditions have in their historic documents statements that marriage is something that happens between a man and a woman, as you probably would expect of that period. Since then, the United Reformed Church has made no clear definition of marriage at a denominational level, and today the General Assembly, our governing body, has still not pronounced on the matter. It hasn't had time since the issue really came onto the serious political agenda. That's not the end of the story, though, because in our tradition we lay a lot of stress on subsidiarity. A lot of matters are dealt with at other levels of the Church than the General Assembly, and it has been recognised that there is considerable diversity of opinion on same-sex relationships generally within our denomination. We went so far as to recognise the sincerity of the different opinions and commit ourselves to live together. When it came to civil partnerships, the General Assembly gave a green light to local churches taking their own decision whether or not to host civil partnership on their premises. And it is possible, we cannot predict this, General Assembly doesn't meet again until 2014, but it is possible that the same decision may be taken in relation to same-sex marriage. Therefore, there may be local churches that wish to host and facilitate same-sex marriage. There are certainly many who would not. I mean, I do not for one moment deny there is a considerable feeling that same-sex marriage is just ontologically not possible and would require a major change of fundamental theological principle. There are others who interpret the essentials of that principle in a way that could be that could accept under modern conditions same-sex marriage as a possibility.
I congratulate you on using ontological. You're the first of all the religious people before us to use the word ontological. Not even the Catholics got that in. But I mean, Mansfield College Chapel has Cicero and Dante and all sorts of people on its walls. It just seems a bit odd that the college, you know, the denomination that had that breadth of theological and soteriological attitude would not want to have the same attitude towards LGBT marriage.
Well, I mean, there are feelings that the unity of the church is important, and to preserve that unity, the URC must avoid giving its denominational blessing to a step that many would find unacceptable. There are also feelings that this is a matter of conscience, that individual consciences are reflected in the membership of local churches, and that local churches should do their own thing. Now, I repeat, I cannot predict whether local churches of the URC will in fact be free to do their own thing or not, but we do have a concern that the bill should not place artificial obstacles in their way if that is denominationally possible, and that is really the reason why we have evidence to give here.
Mr. Quating?
Thank you, Mr. Hood. Just a very general question. What role do you think a government or parliament has in defining marriage, which obviously for your churches is a sacred ritual? I just wanted to get some impression of that.
I think prior to this piece of legislation, that was not a question that the Methodist Church was actively considering in terms of a legal definition of marriage. I think, however, the Methodist Church would recognise that the situation in respect of civil marriage and its civil registration has always been based on a rather broader understanding of marriage than that which has previously been defined in statute. Sure. And I think what this piece of legislation has done is, in a very particular context, for the jurisdiction of this Methodist conference, has brought into rather sharper focus a question that's clearly been around in a number of other European countries for a very long time, when there's been a greater separation between civil and religious marriage.
If marriage is going to produce legal effects, then I think the legislature and the democratic society has an interest in determining what exactly will produce those legal effects. The legal effects have differed over time. I mean, at some point in time, they involve the one spouse ceasing to have any control over her property while the other one had all the control. That doesn't happen now. There is still, for example, an obligation to support which the law has an interest in. There are responsibilities in relation to children, whether adopted or natural, which the law has an interest in, and so on. The further interest that I think the law now has in a climate where equality is considered to be important is to make sure that legal institutions do not by themselves perpetuate inequality unless there is a very good reason for it. And I think it's inevitable that the law has come to focus on marriage as one of the ways in which it has to strike the right balance.
But, I mean, clearly, forgive me, Mr. Clearly, in respect to this legislation, there is a tension, is there not, between the state and how the state defines marriage and the religious denominations that we have. And this is manifested in the quadruple lock, which is a phrase I've never heard of before, but clearly has been designed for this particular bill. Do you think, how secure do you think the quadruple lock is? And from my point of view as a Member of Parliament, it seemed odd that if we were pursuing going down this route of equality, it seemed odd that we should be ring-fencing, if you like, the Church of England, protecting it. What do you think about that?
Well, the quadruple lock, I mean, one of the four limbs of the quadruple lock is solely concerned with the Church of England, and if I could leave that one on one side at the moment, since the URC has not asked me to speak about the Church of England, if you insist, I'll come back to it. The other three limbs are themselves really two, because one says churches can opt in, and another says churches will not be compelled to opt in. So really you could regard that as two sides of a coin. And then you have the equality law aspect of the lock. Now, my view is actually that if you have confidence in one of the locks, you have to ask why you need the others. The Equality Act provision, which takes the form of a new Section 25A that the bill inserts into the Equality Act, that, as far as I'm concerned, is the all-important thing, because it is only equality law which could ever, to my mind, make the owners of buildings feel that they are bound to acquire a certain license, if you like, for those buildings. The owner of a grocer's shop is not forced to get a license to sell alcohol simply because the possibility is there. Sure. It is because of equality law that there are fears that religious groups may be forced to exercise what would otherwise be entirely in their discretion. And hence, I believe that the important thing should be to get all the protections you need into Section 25A, so that equality law cannot be used to force a religious group into something it conscientiously cannot do. If you do that, the other part of the quadruple lock becomes unnecessary, and this is represented by Clause 1 of, Clause 2, Subclause 1. A person shall not be compelled. Furthermore, there is a concern in the way that that subclause is now drafted, because that subclause is the product of, obviously, a lot of work in the government department concerned, and it's been cut down from an earlier wording which said a person shall not be compelled by this act to do various things. Now, that wording didn't really mean very much, because the act is a permissive act. It wasn't going to compel anyone to do anything anyway. Sure. What was necessary was that a person should not be compelled by equality law to do these things, and Section 2.5 does that. If you have the wording that simply says a person shall not be compelled, then you have the difficulty that forms of compulsion with which the law should not be concerned can be challenged in court. For example, compulsion under the internal rules of a religious body, which should be free to decide for itself what its ministers do, or what its other office bearers should do, or its members. And also compulsion in the sense of the enforcement of the trusts of religious buildings. If I could just explain that latter point, trustees are creatures of the law. They are not creatures of the rules of internal traditions, internal religious traditions. The sort of thing that internal religious traditions have are the chief rabbi or a bishop or a council of the church, as in the URC, or a prophet or whatever, but it is trustees to whom the marriage legislation gives the power to apply for buildings to be registered. There needs to be something, therefore, that binds the trustees to the directions of a religious authority. And if the bill as it stands becomes law saying a person cannot be compelled, we may have trustees going one way or the other without any religious control.
So my rather sort of cloudy conclusion, I suppose, because I followed most of what you said, but not everything, is that you don't feel that the quadruple lock, as provided in this bill, is necessarily as watertight as it could be.
Leaving the Church of England on one side, I think what is necessary is a clear, comprehensive provision in the Equality Act that nothing in that Act will compel people to do the various things that we're concerned with. Having got that, I don't think the other provisions are even helpful.
And you left the Church of England to one side, but just for the interest of the committee, I mean, what is your view, your personal view, if you like, about this protection for the Church of England?
I'm reluctant to answer that because the United Reformed Church has appointed me to be its witness on matters concerning that church, and where I have a view in relation to the Church of England, I know perfectly well that my view is not shared in the councils of the United Reformed Church. Possibly, therefore, you wouldn't want to hear it here. If you really want a personal view, I can, of course, give it.
I would like that very much.
Well...
can you make a written reply to it? Yeah.
I can do that in writing.
I'm perfectly happy.
I will certainly provide that in writing, but it will be a personal view, not a URC view.
Jim Shannon.
Thank you, gentlemen, for coming along. And listening to the Methodist Church, I'm keen to get your, obviously, I welcome your and both of your comments. Have you had from your congregation concerns for those who are teachers, for instance, who may be registered as well, and how they feel at this so-called quadruple lock?
Mr. Shannon, I'm sorry to interrupt you, but members are saying they can't hear you up here. I don't know if you're
Well, I'm trying to direct the questions to the...
but if you direct your questions through the microphone, we'll all hear your questions.
Yeah, that's brilliant. Can I ask you a question in relation to the teachers and registers? You'll have people in your Methodist Church organisation who will very clearly have opinions in relation to how this quadruple lock will ensure that they are not impacted in their jobs. We have evidence individually, collectively, that would indicate that many teachers would have concerns. Have you had those concerns expressed to your congregations in the churches that you're in? And also, just I'm keen, when you say you don't have a direct direction over the Methodist Church in Northern Ireland, have you had talks with them to gauge their opinion? A question to yourself, Dr. Pearce, is in relation to and I'm reading the background information, it refers to the Polity Advisory Group, and you mentioned the Baptist Union and also the Church of the Latter-day Saints. Are those two churches that you have direct contact with, that when you come here to express your opinion, as an opinion on behalf of those churches as well? Those are my questions. Hope that's a wee bit clearer, Mr. Chairman.
Thank you.
I have, and my office has not received any written submissions in respect of Methodists who may be teachers and registrars. I'm sure in time some of those will be articulated in a way that we will hear. I think I would rely on the professionalism of teachers to make the distinction between their own personal beliefs and that which they are required to teach as part of a curriculum, recognising that from time to time, I dare say some of us have not always said things that we ourselves personally believe. I mean, I think there's the requirement upon those who are in those particular professions to discharge the duties required by them in terms of their employment. In respect to your question about Northern Ireland, we've not initiated a formal conversation with the Methodist Church in Ireland, which covers the whole of the island of Ireland, but will do at some point when it's clear about the progression of the bill and an appropriate point in the life of the two churches.
On the question of teachers, I am not personally aware of particular concerns from United Reformed Church members who are teachers about what the bill might or might not require. But of course there's no reason why I should be aware of it. Apart from my law and polity role, I am basically just a member of a local church, and the concerns would not come to me. On the question of teachers, I very much agree with what Mr. Powell has said, that a teacher has to prepare children for the world which exists around them and out into which they will go. And if that is a world in which people of the same sex marry each other, just as it is a world in which divorce sometimes happens, they should prepare children for that. It doesn't mean they have to advocate same-sex marriage or divorce. You asked me about the Latter-day Saints and the Baptist Union. I think the only context in which I mentioned them was simply as illustrations of different types of church polity. The Latter-day Saints, very much a top-down institution in which doctrine and policy are determined ultimately in Salt Lake City and are carried out by individual wards of the Latter-day Saints all over the world. The Baptist Union, a federation of independent congregations where ultimate decision-making lies at the local level. The United Reformed Church is somewhere in between the two. That's the only point I was making regarding them. I haven't contacted them in any way. That is simply, I think, fairly general knowledge for those who know those traditions. Was there another question?
Just wanted on the question that you mentioned there about teachers in school and preparing people for life. If teachers had a genuine religious conviction and opinion that prevented them from conveying perhaps the full teaching, the full indication of what same-sex marriage wanted, do you feel there should be guidelines set down to enable teachers with convictions, religious convictions, so that they aren't impacted inadvertently or wrongly by any legislation that comes through?
There may be a case for that in some instances. I don't have enough briefing on the detail of what might not be required of teachers to answer that with any specificity, really. I mean, by and large, obviously, schools should not be compelling teachers to say something that they don't believe. Whether they should have to deal with a subject they find distasteful is a slightly different question, and perhaps in some cases it is necessary in order to do their job.
Tim Lawton.
Thank you, Mr. Hood. Can I just ask you both briefly, what are your two churches' attitudes towards homophobia, and do you think that homophobia is a big problem in this country today?
The Methodist Church abhors homophobia. I think it's as simple as that. I mean, the slightly longer answer that appeared as fudge is a reflection of that the Church has engaged in a process whereby some of the fears that are inherent in homophobia and some of the consequences that are felt as a result of homophobia are rather better and rather more clearly understood in the life of the Church and in society as a whole. I think that clearly one's experience of homophobia will, I would have thought, be largely defined by one's particular experiences and the sorts of circles that one moves with and even perhaps one's own sexuality. I think we would acknowledge that there are occasions when there are significant instances of homophobia, and that is simply unacceptable in life and seeing creation as being valued by God.
And can I do a follow-up and then perhaps Dr. Pearce his view on that? Do you think this bill will do anything to address the problem of homophobia?
Well, I think it will insert in contexts. Yes, I think the key point that we have observed in charting the piece of legislation is the inordinate difficulty of being able to have a conversation about the merits of the legislation in a rather, I wouldn't want it to be a hermetically sealed unit, but seeing it outside the debate as to whether or not one thinks homosexuality is right or wrong. And that I think has been a great shame, that the merits or otherwise of this piece of legislation has not been clearly understood. It's been coupled to another conversation in some instances for other reasons.
Dr. Pearce?
On homophobia, generally, I'm not sure I can add a great deal to what Mr. Powell has said, because the United Reformed Church also believes in treating people with respect. It sees no reason to be frightened of homosexual people. It does have an equal opportunities policy, which would make it unacceptable for those who work for us to insult people, for example, on the basis of their sexual orientation. We don't regard the holding of a serious conscientious view that same-sex relationships are wrong as homophobia by any means. Many of our members do hold that view, and that is equally respected. I'm not sure I can say a great deal more about that question. Could you remind me the other issue that you raised?
Whether my take on all this is that we still do have a problem with homophobia in society, and that is what needs addressing.
Yes.
Whether this bill can add to that is what I'm asking.
I believe
your view
that
on.
this bill is one of a number of measures which over the years may normalise same-sex relationships. It would provide a context in which they are less different than they are at present. Now, in the case of divorce, it became possible to get a judicial divorce in 1857, but it was still very much sort of beyond the pale for anybody in polite society to do that. Divorce became a lot more frequent as a result of changes in 1936, and gradually over the years since then, children are no longer stigmatized because their parents are divorced. People are allowed to do all sorts of things as divorcees that they couldn't do before. That's sort of gradual change, with the law not actually forcing anything, but simply terminology, and terminology is very important in this, terminology leading the way people think. Obviously, that is unfortunate for those who think that same-sex relationships are wrong, just as the change with divorce was unfortunate for those who thought that was wrong. But in terms of gradually making homophobia less prevalent, I think it will slowly but surely have effect.
Kay Green.
I'm not sure if either of your institutions marry people in premises other than your own, for example in armed forces chapels or chaplaincies. If this legislation passes, all denominations using a particular building would need to agree that any one could hold same-sex marriages in those premises. As you may not decide yourselves to offer same-sex marriages, do you envisage that you would want to prevent others from using premises to do so, where you also use the premises to conduct marriages?
You're thinking there, presumably, of premises that may not be subject to a sharing agreement under the Sharing of Church Buildings Act, but are nevertheless commonly used, because I think the Sharing of Church Buildings Act does, as it currently stands, recognise some of the tensions that are inherent in terms of different practices. I think the question of, well, I suppose it's armed forces chapels are the most obvious,
yes,
aren't they? I think, and that would clearly need to form part of the Church's consideration of the whole question of same-sex marriage, and I don't mean that to be another fudge. I think it is genuinely part of the process of discernment that the Church would be engaged in. I think the Church would recognise, however, that it had no legal authority over those particular chapels. So that the Church could only make a decision, the Methodist Church could only make a decision with regard to premises, of those premises that are either held on the model trusts of the Methodist Church or are deemed to be Methodist premises.
So you wouldn't want to control the behaviour of other institutions in premises like armed forces
right.
chapels, and therefore that would effectively require you to give consent to others conducting same-sex marriages on those premises if they wanted to.
In as much as we had any consent to give, yes. The question, however, of whether or not a Methodist minister could officiate at that is another matter, yes.
Yes, different question. And for the Unitarians? The
United
Reform. Sorry, I was ahead of the last session.
Yeah, sorry. We begin with the same four letters, but yes. This is actually, I'm really grateful to be asked this, because this is the issue on which we have the greatest concern. Not so much from the point of view of the United Reformed Church if it should decide not to solemnise same-sex marriage, or even at the point of view of an individual local church which decides not to do that. Because if a local church does allow another group to use the premises and that group wishes to have same-sex marriage under its auspices, I think it would be perfectly possible for us to make clear that it was the guest group, if you like, and not the United Reformed Church that was doing that. And I imagine that if the bill becomes law in its current form and a consent to use is required from us, that consent to use might well be forthcoming. I can't speak for the General Assembly, but I think it might. Our concern is with the other side of the coin. What happens if the General Assembly says yes, and there are local churches who wish to solemnise same-sex marriage, but they meet in a building which is jointly used? At present, as you rightly say, whether it be under the consent to use mechanism or the consent to same-sex marriage mechanism, one way or the other users of the building would have a veto over our ability to do that, and that we find unacceptable. The idea that a guest church, for example, which is using the United Reformed Church's building because its own building is being renovated, or because it consists entirely of asylum seekers who have very little resources and certainly couldn't afford their own building, or even, let us say, a hospital chapel which doesn't belong to any religious group, but where United Reformed Church members worship at one time and Roman Catholic members worship at another time. The idea that one denomination should have a veto over the activities of the other is something that we find very troubling. And we find that troubling even though the United Reformed Church may never wish to do this. It is still possible that other religious groups may. And we don't see that this makes sense.
I'm very grateful for that answer.
Simon Kirby.
Thank you, Mr. Two questions about protections which we've discussed previously. Would you agree with Lord Panic that it would be very difficult to craft improvements to the protections currently contained in the bill? And secondly, do you agree that for both the Church of England and the Church in Wales there is a need for a different route to opt in the bill because of their obligations under common law, and in the case of the Church of England, their canon law?
I've already agreed at the chairman's suggestion that I'd put something in writing regarding the Church of England. If I could leave my comments on that and the Church in Wales to my written comments, I'd be very grateful. But so far as other religious denominations are concerned, I totally agree respectfully with what Lord Panic said on Tuesday.
Yes, I think broadly I would conclude with that view of Lord Panic. I think we recognise that there would be some strengthening in terms of identifying the relevant governing body in a schedule as being the Methodist Conference. That would simply mirror existing legislation in respect of the Sharing of Church Buildings Act and the Methodist Church Act of 1976. I think in respect of the Church of England and the Church in Wales, it is for those bodies to comment. We recognise, however, their very particular position, both in terms of common law and ecclesiastical law, with respect to duties in respect of marriage.
Thank you.
Stephen Dowdy.
Thank you, Mr. Chair. Just to follow a little bit on from my Honourable Friend's comments earlier on about the sharing issues, how many examples of that are there across the country in terms of sharing between Methodist, URC, Church of England in some cases, whether it's in military chapels otherwise, or indeed in actual church buildings? Because I've seen quite a few, just idea of the scale really.
Yes, I don't have the numbers available. I can provide those if that would be helpful to the committee. That the majority of sharing agreements would be, from the Methodist point of view, either with the Church of England or with the United Reformed Church. And of course, the question in respect of forces, chaplaincies, would I imagine be pretty common across those bases where we have a presence. Again, I could check that for the committee.
And is it just sharing of buildings, or is there sharing of anything else? Because I've been to one of those locations, and often it is literally the same congregation that may be turning up, but having a slightly different service, or perhaps a different minister each time.
Yes. Without taking us down the path of the, I think, 6 categories of local ecumenical partnerships, largely because I can only remember 3. I think yes, there will be a variety of situations where, in some instances, it is simply a sharing of the building by separate congregations, and in other instances there would be one congregation sharing a building, and there would be more of the former than the latter.
And how would the decision-making process then work, where there is more of a sharing than just the building? Because if an individual, say, congregation wanted to opt in, who happened to be more dominated, say, by the URC, if they allowed that, how would those opt-in arrangements work? Would there have to be an agreement amongst them, or again, would it be vetoed? Say the Methodist Church didn't agree to go ahead with same-sex marriage, but URC members did. How would that work?
Well, I think that would be part of the consideration of the whole question and the series of questions raised by the bill, if and when the Church came to address that question. It's not without precedent in that there is some permission within the Sharing of Church Buildings Act for that already, and of course in some instances where congregations are sharing either worship and or buildings, some level of accommodation has already have to be made around the question of the marriage of people who have previously been married, infant baptism. So I think in terms of considering the implications of the bill, we would be looking to the precedents created those.
Could you share some further information on that in terms of how that works for example, a marriage of divorcees and so on, how those decision-making processes
Yes, I
work?
can put that in a written
That would be
submission,
really helpful. Dr. Pearce, is something?
I'm afraid I'm no more helpful on statistics than Mr. Powell is. Could I just say, though, that the bill, in what it's putting into the 1949 Marriage Act as sections 44A to 44D, describes 3 different categories of building in joint use. There are those subject to a formal sharing agreement under the 1969 Act. There are then those covered by Section 6.4 of the 1969 Act, and I suspect that since that section is not quoted anywhere, most people will have skated over it. That section is actually a catch-all which repays careful investigation as to the type of situations where the veto would apply if the bill becomes law as it stands. Then there are other shared buildings, and in respect of those, the whole question has been left to be dealt with in regulations. What I would like to see, if there's going to be any veto provision at all, is for the whole thing to be dealt with in regulations so that religious bodies can actually come together and talk about what their real concerns are, both positive and negative, before the law becomes fixed. The sharing agreement situation is the one in which there is the greatest moral case for a veto, because that is where different churches have agreed to act cooperatively in sharing one building and to consult each other on what they do. My main comment there is, if they're going to do this in a formal agreement, why can that agreement not also provide for the question of same-sex marriage? And that why, therefore, can the bill's veto not be made subject to what a sharing agreement says?
David Barrett.
The number of members that you have.
61,627 in October of last year.
Hallelujah, that number, the 7th.
In terms of membership, it's around 260,000 with what we would class as a community role of an equal number.
Okay. In terms of the buildings, actually, just to kind of take it a stage further in a different direction. Say down the line, the conferences decide they want to opt in relation to same-sex marriages, and knowing that your buildings are well used by a variety of organisations and Christians, different denominations. Knowing also that there are those that use the premises for weddings, and that those denominations also will continue to have and hold a traditional view of marriage, would that impact upon their continued involvement in your buildings if down the line you've come to a view that you uphold same-sex marriage. And also any other organisations and charities that I know that well use your buildings. Say, for example, a marriage guidance charity that similarly upholds a traditional view of marriage. Would that affect their continual involvement?
Well, under the provisions that we have for use of our buildings, there is a requirement that that nothing takes place on the premises that are not in accordance with our standing orders. But the question, of course, of what is, as it were, taught by other religious groups that use our premises is also covered by internal legislative provisions, so that nothing can be taught that is contrary to Methodist Church doctrine. I think the particular point of interest that you raise would be, for example, an organisation that was providing marriage guidance or marriage preparation. And I think that's one of those areas that we would need to return to once the Church had reached a decision on its view of same-sex marriage. And how it sought to accommodate, which I think on a number of other areas it already does, I have to say, how it sought to accommodate differing views that it might not totally agree with, but recognise the need for a particular group to have use of a community space.
And have you sought your legal opinion in relation to your earlier reservations concerning Clause 2? I was very interested to hear your concerns in relation to the issue of compelling ministers to perform to participate in same-sex marriages. Have you sought your own legal opinion as a church?
We haven't had the text of the bill long enough to obtain professional legal opinion. We haven't even decided whether that's something on which we feel we need it. I am a lawyer myself. This is my opinion at the moment.
No, but it's also the opinion of Robin Allen QC on behalf of the ECHR.
I'm glad to hear it.
EHRC, sorry.
Yeah, I haven't seen his opinion.
And it may be interesting for you to discuss with them some of your concerns on Clause 2 in relation to concerns on religious freedom.
Yeah.
Ben Bradshaw.
Mr. Powell, we heard from your Anglican colleagues that they're currently actively reviewing their whole theology of human sexuality under this review, I think under Sir Joseph Pilling, and that there may be changes in their approach to civil partnerships. Is the Methodist Church undergoing a similarly active review, or is that in prospect?
Well, as it happens, the Methodist Conference last year was asked to reconsider the Church's position in respect of the blessing of civil partnerships on Methodist Church premises. Knowing at that stage, because the conference met in July, knowing the potential existence of this piece of legislation, the Methodist Council, which meets between conferences, took the view that it would put a pause on that piece of work, simply because it would seem more sensible to undertake the work in light of this particular piece of legislation. So the short answer is yes. It's actually in the context of a particular question about civil partnerships, but it would now seem very sensible to take the two items together.
So your position's under review?
Yes, I mean, as the one responsible for the formulation of the agenda, I'll be inviting the Methodist Conference in June to say whether or not it wishes to engage in a more formal review and the extent of that review.
Order. I'm afraid that brings us to the end of the time allotted for the committee to ask questions of our witnesses. I thank you, Reverend Powell and Dr. Pearce, on behalf of the committee. The committee will sit again for consideration of the bill at 2 p.m. this afternoon. Order. Order.
Portcullis House, the Boothroyd Room.